Welcome to another in the series of legal videos from Dindinger and Kohler Law Firm here in Boise, Idaho. Today again we have with us Edward Dindinger. Good morning, Edward.
Good morning. Beautiful day here in Boise.
It is. So today we're going to talk about custody and divorce. Can you tell us, Edward, how Idaho judges decide on custody arrangements?
Sure. So the overarching consideration is what's called best interest of the child. That's actually found in statute, Idaho Code 32-717. Underneath best interest of the child, there's a number of factors that the judges can consider. Among those are wishes of the parents, wishes of the child. On that factor, the weight given to the wishes of the child increases as the child grows older. The interactions and relationships between the child and the parents and the child and his siblings, the child's adjustment to his current school, home, community life, the character and circumstances of all the individuals involved in the case, not just necessarily in the home, continuity and stability in the life of the child, and also the presence of any domestic violence.
Thank you. I think a common misconception is that mothers are given preference in custody decisions. What do you have to say about that? What's been your experience?
Yeah, I think that certainly is the common knowledge that mothers are given preference in custody arrangements. I think that is less and less true as time goes on, and certainly we've been successful in getting dads custody arrangements that they seek and work for them. I would say that the sense in which it's true is in the case of very young children. I think there still is a bias toward mothers in granting custody of very young children, but I think once the children are 8, 9, 10 years old, that starts to dissipate. And of course, once they get to that age, then the wishes of the child start becoming more important also. So I think that negates some of that effect.
Okay. What are some common outcomes when there's been a parent that's been exclusively a stay-at-home parent and then encountering a divorce? What tends to happen custody-wise there?
Well, the thing about the stay-at-home parent is what kind of stay-at-home parent were they? Were they a good stay-at-home parent? Were they taking care of the child's needs? Or were they just kind of putting the kids in front of the television and letting TV raise the kids? That's going to be a consideration. Certainly, as we mentioned before, one of the factors judges consider is continuity and stability in the life of the child. So that could weigh in favor of the stay-at-home parent. If that was the primary caretaker before, it's likely that person, will have standing as a primary caretaker going forward into the future.
So what happens, it seems increasingly there tend to be accusations from one of the spouses toward the other.
I'd like to say that allegations are just allegations until they're proven, but of course they can carry weight, but that's going to be something judges are going to have to weigh based on the credibility of the person making the allegation, any other evidence that supports that allegation, if there are other witnesses to the alleged conduct. All those things are going to come into play. Divorce and custody battles are some of the ugliest things we find in the law, and so it's not uncommon to see some very ugly allegations leveled, which is unfortunate. It's unfortunate for the people making the allegations, and it's unfortunate for the children, of course. Regarding sexual impropriety, I would say adultery in Idaho is still officially classified as a felony. It's not enforced. It's not generally prosecuted as such. But in the context of a custody battle, if there is adultery, I would really recommend holding off on bringing that adulterous boyfriend or girlfriend partner around the children. That is one thing that judges do care about in these custody situations. If you're seeing somebody else, judges don't like you exposing your children to that person very soon after the breakup of their parents. So that is one thing I would caution people about. If there is that kind of thing going on, just be cognizant and be very careful about what you expose your children to.
Under what circumstances would extended family members be eligible for custody, like grandparents?
Right, so it's kind of interesting situation. So under the Idaho Code we talked about earlier, 32-717, there is a provision that says where the children have been in a continuous and stable relationship with the grandparents, it is possible for grandparents to be considered on the same basis as parents for the purposes of deciding a custody arrangement. It specifically refers to grandparents, doesn't refer to any other extended family members. Now there are cases, Troxel v. Granville, which was a case out of Washington, eventually decided by the United States Supreme Court, which makes it fairly clear that the parents still have the primary consideration. So the interplay between what it says in statute and what the case law is can be interesting sometimes. Certainly it's not impossible for grandparents to get visitation rights or even primary custody. I've seen it happen many times, but it's by no means a guaranteed thing.
So for our viewers who may be considering divorce or in divorce process, or maybe even post-divorce, just with a custody plan that they're not too thrilled about, what are some of the things our viewers could do to improve their odds of getting the custody arrangement that they feel is best for their children?
Sure, and I'm glad that you mentioned post-divorce and where there might already be a custody order in place. If you're trying to alter an established custody order, the standard is going to be, well, of course, best interest of the child, but to get a modification, you also have to show a substantial, material, and permanent change of circumstances. That could be getting a new job, that could be moving closer or farther away from the child, changes in the family dynamic, things like that. In general, I tell my clients, and especially in divorce and custody situations, your objective is to look like the more sane and reasonable person. Everything that you can do to make yourself look more calm, more normal is really going to help you out. So, text messaging, for instance, I think texting is great because it can avoid some of that. If there's interpersonal conflict going on between the parents, texting can kind of minimize that if it's done correctly. You don't want to get dragged into these crazy, long, drawn-out text battles. That's a really bad idea. You should always operate with the assumption that a judge is going to read whatever you put into writing, especially in text messages. I tell my clients there's 3 simple rules for texting the other parent. I say, don't use all caps, don't use exclamation points, and don't swear. If you can avoid those 3 things, you're going to be in a much better position than someone who does those things.
So why would it be beneficial, in your opinion, to seek an attorney as far as coming to an agreement on custody arrangements versus just trying to hash it out with your partner?
Sure. Well, especially in a situation where there is a high degree of interpersonal conflict, having an attorney kind of takes you out of that direct position, where there's emotions at play. The attorney can be a more objective person to negotiate for your interests and the interests of your child. And of course, attorneys, we do this all the time. Most people don't get in custody battles on a regular basis. I certainly wouldn't wish that on anyone. But as attorneys, we are in a unique position of the knowledge and expertise to get you what you want and do so in a way that can really minimize that family conflict that, as I said before, is really harmful to everyone involved.
So is it possible for 2 divorcing parents to just decide on their own custody agreement and, just like a verbal agreement of what they're going to do?
It certainly is possible for the parties to reach an agreement. We would call that a stipulation, and both parties put it in writing. They both sign off on it. If the parties are represented, their attorneys will sign off on it also, present it to the judge, and the judge usually signs off on it. Now, of course, nothing negates that overarching best interest of the child standard. The judge can always reject any proposed stipulation or custody arrangement on that basis. I do find it, if it seems reasonable and it seems like it's going to work and it's going to reduce family conflict, judges are pretty likely to agree to it. If it seems very strange to the judge, that might be another issue. So again, that's a good situation to get an attorney involved in to help you craft a stipulation that will pass the judge's muster.
So what you're saying is no matter what type of agreement you come to, whether it's on your own or a handshake or whatever with your soon-to-be former spouse, the judge is still going to have to sign off on it?
Yeah, absolutely. I mean, if you want a custody order in place, and in a divorce, there has to be a custody resolution. So if any of you have a family law issue, I strongly recommend you contact a lawyer. You can certainly call us. We do a lot of family law cases, and we do achieve really good results for our clients. You can call me directly. I'm at 208-713-8620. You can email me at edward@dklawboise.com. Visit us on the web at www.dklawboise.com, or find us on Facebook, facebook.com/dklawboise. Hope you enjoyed the video. Look forward to speaking to you next time.